the morning sports page here on 750 The Game. And in studio once again is Colin Amos from Goldberg and Jones, the law offices of Goldberg and Jones, 1-800-DIVORCE. Colin, good morning. It's great to see you once again.
Good morning.
How are things going?
Good. I made it in this morning, driving in that slushy snow, rain, whatever it is.
Yeah, you live out in, Camas, so what was it like up there? Was there snow on the ground?
It wasn't snow on the ground where I was, but it was slushy rain, and I got in, finally. It wasn't bad, but I decided not to go running outside this morning.
All right, if you are in need of some counsel, you can call 1-800-DIVORCE, and Colin will give you a free consultation over the phone and answer questions that you may have. And we'll start out this, Colin, with some of the questions that you have from your website, and it gives you a chance to answer these. This one comes from Portland. It says, my wife and I have been in counseling, and it has been suggested that we consider separating from each other. We have a 13-year-old daughter, and my wife doesn't work. This will pinch us financially, so I'm reluctant. Is there anything else I should be concerned about?
And the answer is hell yes. Yeah, definitely, because a lot of people, I'm a bad marriage counselor and a good divorce attorney, and the problem is people are trying to fix their marriage, and men especially maybe move out. They continue to have the same bills, but now two different households. And what you do is you set quite a significant precedent for yourself. Let's say that you separate for 6 months. Well, what you're doing is your actions speak louder than words when you go to court. So now we have a situation where whatever you've established with your child as far as visitation is what the court's likely going to follow through with if a divorce is pursued. And so you make sure if you're going to separate that you have a good consistent visitation schedule, something that you could say, if a court ordered this for me, I can live with that. Financially, again, you're setting a precedent, especially for spousal support, because in this situation, this caller or this person who emailed, they're the breadwinner. I think that's what they said. They make the majority of the money, and what you pay on a month-to-month basis is going to set some kind of precedent as to what you should pay in the form of spousal support. Assets, debts are still created, and that's all things that can be divided. So if your wife's still continuing to spend money and create debt, you're on the hook for half of that too. So.
All right, Colin Amos is in studio with us right now. If you have a question, about a parenting plan or a divorce or anything in that area, call now at 503-417-7575. The next question comes from Beaverton. It says, I have two young children, 2 and 4, and my wife and I aren't getting along. She wants to take a break and go stay with her parents for a month in California. I'm afraid she might decide to stay there. Can she file a divorce in California after 30 days? Also, can I make her bring the kids back?
Yeah, good question. With regard to the issue of filing, no. All the states have adopted a statute that really keeps decisions with regard to custody and visitation in a home state, and the home state is defined as where the child or children have resided 6 continuous months prior to any legal action being filed. Many states also have a residency requirement that requires you to live there a certain period of time before you can file a divorce. Oregon does 6 months. I'm not sure about California, but regardless, you can't file anything related to the kids in California for at least 6 months. But the other part, can I make her bring the kids back? Now we're getting into a bit of a problem, because once they're establishing a new routine down there and she says, oh, well, I've decided to stay. It's sunnier. My parents are here. They can help me with the kids. You're going to have a difficult time getting a court to now order her to return the kids, and you can't get into court right away. So you might be 2, 3, 4 months later and have a court decide, and now we've got a precedent. All
right, 503-417-7575. Let's grab the phones, and then we'll go back to the questions that you have here, Colin. Plus, I just got an email that came in. Let's go to Kevin, who's in Portland. What's up, Kevin? Fire away.
Hey, just have a question for you. We had a mediated parenting agreement, and they did not include the taxes of who claims the child in a joint custody. And now she's trying to say that she's going to claim every year. So we had a verbal agreement before that was done.
So in this mediated agreement, did you finish the divorce, or you just have a mediated agreement and you haven't filed yet?
We were never married.
Okay, just in a custody arrangement. So did you have a court order essentially incorporate that mediated agreement into your final custody order?
No, it's just a mediated agreement because for the county DA for child support reasons.
Okay. Well, are you in Oregon?
Yes.
In Oregon, the presumption, they follow the federal rule, which is where the children have resided more than half the year, that parent gets to claim the kids on taxes. So if you had them more than 50% of the year per this mediated agreement, you would get to claim them.
Okay. Even though she verbally agreed to an every other year thing? That's
why I'm concerned about mediated agreements, because mediators are trying to get an agreement. It's not necessarily a complete agreement. They're doing the best they can under the circumstances, but all of these little details really make a big difference, especially, taxes or things of that nature. And, oral statements are not binding or enforceable, and so it really is a problem. We really want to get it down in a court order. We always address the tax dependency exemptions. In Oregon, the presumption, even in a divorce or a custody case, is that parent that has them the majority of the time would get to claim them. In Washington, they alternate the dependency exemptions every other year, so maybe both move up to Washington.
Hey, I appreciate the call, Kevin. Thank you. Let's go back to the phones and bring on Perry, who's in Portland. What's up, Perry? Fire away.
Hey, I have the original marriage agreement that you have signed, and it gives you 60 days to get married, was actually forged. My name I didn't sign my name, and the Social Security number was put on there by her. Now it's 5 years later, and we're divorcing. Do I have any grounds with that being the fact that that original document was forged, or the fact that I went through with the ceremony, it wipes that voice right off the table?
Well, I haven't heard much about a 60-day agreement prior to marriage, but I think basically the answer to the question is if you go through the formalities of getting married, you're considered married. There might be some defects, but not necessarily enough to void the marriage. So you're pretty much on the hook with regard to that 5 years and then resolving issues in the divorce proceeding.
All right, let's go to one of the emails that just came in. It says, question for Colin. I've been going through a divorce over the past year. As of September 1st, I have had a majority custody of my six kids. The temporary custody is for 50-50 custody, but the 4 oldest refuse to spend time with their mother. The 2 youngest are still doing 50-50. She has a job, and I pay her $800 a month, yet she pays nothing for child support. Is there a way to get me a temporary child support from her? Do I have to have a judge change the temporary custody order before I can get child support from her?
That's a good question. I mean, 6 kids, and this guy's really pushing through things. That's great. Yeah, I mean, you have a temporary order, and it is just that. It's temporary until we can get to court and finalize this case. The court is reluctant to make really more permanent decisions just because they don't know how things are going to play out. Obviously, things are playing out pretty significantly here. If you're in Oregon, you can get some maybe their voice heard through an evaluation or a guardian ad litem. But the key here is, yes, when you go to court for that final order, you need to have your ducks in a row, really bring home the fact that these kids are with you, 4 are with you on a more significant basis, the other 2 are 50-50, and the calculator will then push the child support your way, or it should.
All right, let's go back to the phones. LC is on hold. LC, you're up with Colin Amos. Fire away.
Hey, I got a question. We have a mediated agreement. Currently, I have every Wednesday and every other weekend. My son's 11, and lately he's been asking to switch the schedule where his mom would have that schedule, and or we would go to a 1 week off thing. What is the steps in to get that updated, and what do I need to do to get that changed?
Hey, thanks for the call, LC.
Are you in Oregon?
Oh, let me put him back on here for you. Are you in Oregon, LC?
Yes.
Okay. Well, this is a good question. One of the other questions on the email that emailed in is, when my kid turns 12, do they get to choose? And the answer is no, not technically. But, kids have a voice. They want to be heard, but the court doesn't like to, and understandably so, get them too involved in the day-to-day decisions, because then, they get in front of the court and parents are putting pressure on them. But the way to essentially get that child's voice heard is through a modification and then a custody evaluation, where certainly the custody evaluator can look at the totality of the circumstances, and if there are good reasons why this child wants to be more involved. It's also, without that evaluator, you can go back to court. What you have is a cookie-cutter parenting plan, every other weekend, 1 evening a week. The courts are very receptive to shared parenting arrangements as long as you can really demonstrate why it'd be best for that child to have more significant time or a more significant parenting plan with you.
All right, here is another question from Vancouver. It says, my girlfriend and I have been together for a long time, 14 years, and we have a 12-year-old son. We are breaking up. Is it true that at age 12, kids get to choose which parents they want to live with.
Yeah, that's exactly the misnomer. A lot of people out there believe, my kid's 12 and he can make life-changing decisions, again, their voice can be heard through alternative means, but no, not directly, technically at 18. Now, that being said, I call kids 1,000-pound gorillas, and when they finally look around and say, hey, this is the way it's going to be, watch out, parents, because when they're 12, 13, 14, if they really decide I'm going to be with dad or I'm going to be with mom, then that's where we end up.
All right, Colin Amos in studio. If you want to contact the law office of Goldberg and Jones, you can do that at 1-800-DIVORCE. And Colin, you'll take them through a consultation, no charge. You can answer the questions and help point them in the right direction.
Yeah, just have them call and just give me a call and I can go through everything with you.
All right, 1-800-DIVORCE. Big thanks to Colin Amos. Colin, thank you so much. We'll catch up with you again in the very near future.
Yeah, sounds great.
All right, Colin Amos, 1-800-DIVORCE. A big thanks to our guests today, Brian Wheeler, Scott Hastings, Jeff Martin, Rob Cornelis, and Colin Amos. For Jason Peterson.